Hello everybody, my name is Kamaho Faith and welcome to Attorney's Corner. In today's episode, we will be discussing the different types of marital property regime systems in South Africa, as well as getting married in terms of customary law, just a bit about that, and also entering into an antenuptial contract. Now, in South Africa, when you and your respective spouse decide that you want to get married, you can either do it in three different types of ways. Either you get married in community of property, which is the default system in South Africa, and entering into a marriage in community of property essentially means that both you and your spouse have separate estates, which are now it's going to come as it's going to be combined as one. It's going to be a joint estate, which means you're going to be sharing equally in your assets and your liabilities. Now, this can be great for financial security within the marriage and also in terms of asset sharing, but it can create a bit of a complexity when it comes to estate management and also that joint liability of debts, because you will have to be, you as a spouse, you will be liable for each other's debts. So that's the bit of trouble that it causes being in community, being married in terms of in community of property. Now, the other part in which you can get married is being married out of community of property with the accrual system. Essentially, what the accrual system means is that each spouse has their own separate estates. Now, when you enter into the marriage and you have certain assets, those assets will be considered as your commencement value at the beginning of the marriage, and then during the marriage your estate will grow. Now, that growth is then calculated and then it will be shared equally upon divorce, and it will be shared to the spouse that is entitled to receive that accrual. So that is essentially what that means. It's just the calculation of the growth of your estate, and then it will be calculated and then it will be shared equally upon divorce. Now, the last one is being married in community of property without the accrual system. Basically, what this means is that I come into it with what I have, you come into it with what you have. Should we divorce, you leave as is, I leave as is. There's no joint estate, there's no sharing of assets and liabilities. What's yours is yours, what's mine is mine. You come in as you are, you leave as you are. I come in as I am, I leave as I am. That's basically what that means. There's no financial obligation in terms of each other when you now separate or when you divorce. You don't owe the other one any of your assets, and the other one doesn't owe you any of their assets, and your liabilities are not combined. It's just we separate on an amicable manner. You leave what you have, I leave with what I have, because what's mine is mine and what's yours is yours. And that's being married in terms of out of community of property without the accrual system. Now, when it comes to customary marriages in South Africa, for it to be valid, there are requirements that must be met. So the first would be that both respective spouses must be at least the age of 18, and they must consent to being married in terms of customary law. And also, the customary marriage itself must be negotiated, entered into, and celebrated in terms of the customary laws. And if it is a minor that is wanting to enter into a customary marriage, the parents or the legal guardians must consent to it. Now, a customary marriage in South Africa, that default system that I was talking about of being married in community of property, it relates very much to customary marriages because they are automatically in community of property. And for a customary marriage not to be in community of property, an antenuptial contract must be entered into and registered. Now, what is an antenuptial contract? An antenuptial contract basically is a legal document or a legal contract. It is registered at the deeds office, and it is before the registration. It must be drafted, it must be signed by a notary, and in front of two competent witnesses, and it must be registered within 30 days of the date of signature thereof. Now this legal document, what it does is just it, I can say it just lists the way that you as partners, you as spouses want your estates to be dealt with in terms of when you do get divorced. Because for the, especially for the protection of each other's assets. Now, there's this misconception out there that entering into an antenuptial contract is planning for divorce. It is the exact opposite. Entering into an antenuptial contract is securing your financial future and the financial future of your respective spouse. Because, let's just say, for interest sake, let's just say you are in love with your spouse, you've been together for 3 years, and now you want to get married, but you have noticed that during the sustenance of this relationship that your partner might be a little bit of a risky partner when it comes to finances. They might maybe have a gambling problem, or not even a gambling problem per se, but they just might be on a higher level of spending than you are, or they have not, they don't even have a risk factor, but they are in a higher earning capacity than what you are, and they have a lot more assets than what you have, and they just want to protect their assets in terms should this thing of called our marriage now go sour, because unfortunately this is life and things happen and people fall out of love. Now, it's nice when we're together and we're getting married and we are celebrating, but we do have to think of the times where it's not going to be so great, and we do need to plan for those times where it's not going to be so great, because when those times come, people become nasty, and it's better to have a document in place already before the nastiness comes, so that there's a bit of control and protection for each respective spouse's assets. So that's when antenuptial contract comes in. It's very nice when we're in love, but we do need to plan for if things do go south and they go left and we are now entering into a divorce. So an antenuptial contract, let's begin with the one, let's just say, I already discussed a bit of what it is previously, but you are entering into an antenuptial contract with the accrual system. Now, as I already explained, that the accrual just means that it's the growth of each partner's estate. It's going to be calculated. In terms of the accrual system, the accrual only becomes relevant at the end of the existing marriage. Now, let's use an example for the calculation of the accrual. Let's just say spouse A. Spouse A at the beginning of the marriage had a net value of 10,000, and during the marriage, it grew up until, well, where they want to get divorced, and at that time, the growth or the net value is 100,000. That is spouse A, meaning that the growth that spouse A had during the sustenance of the marriage was only 90,000. Now, spouse B, which started the marriage with a net value of 20,000, and the growth of her estate during the sustenance of the marriage, now when you get to the end of it, the commencement value is 200,000, which means that the growth that spouse B had during the sustenance of the marriage is 180,000. Now, the growth that spouse A had being 90,000, and the growth that spouse B has being 180,000 is now going to be subtracted from each other. So there's going to be 180 minus 90. Now the result of that is 90,000. That 90,000, that result is going then to be divided by 2, which brings us to 45,000. This then means that the spouse with the smaller the spouse with the smaller growth, being spouse A, because remember spouse A only had a growth of 90,000, has a claim against the spouse with the larger growth, being spouse B, because spouse B had a growth of 180,000. So this means that spouse A can claim that 45,000 from the growth or from the estate of spouse B. That is essentially how you calculate the accrual. Well, how you calculate the accrual. It might be a bit more complicated in a real life situation, but this is just an easy example of how you do calculate the accrual and how how it is divided and how it is calculated and shared upon divorce among the spouses. There are some exclusions there are some automatic exclusions when it comes to being married out of community of property with the accrual system. Now, those exclusions are donations made between spouses. So if my spouse gives me a donation, that is automatically, and it's in the marriage, that is automatically excluded. It can be monetary, it can be, let's just make it monetary. A monetary donation of 100,000, that is excluded. It doesn't form part of the accrual calculation. And also gifts, inheritance, and legacies, those also are excluded from the accrual calculations, as well as damages awarded in terms of defamation and pain and suffering. Those people that have accidents and they receive road accident fund money, those funds are excluded. In addition to the above exclusions, both spouses can also state what they want to exclude, which assets they want to exclude specifically from that accrual calculations. Now, in terms of getting married in community of property, getting married out of community of property without the accrual system, there isn't really much to that. Because as I previously explained, you come in with what you come in and you leave with what you leave with. That is basically what it says. It's as simple as that. Now, entering into an antenuptial contract. If you are late for registering it, you can apply to the High Court to permit you to register it late. It might take some time. And then also, if you do want to change your marital property regime system, you can also do it by application to the High Court. That is a very costly exercise, and it's also might take a bit of time to do that. Most people, let's just say you're married in community of property and you want to change your marital regime property system to out of community of property. Because it's so expensive, most people opt to get divorced and then get married again, which is I believe it's way cheaper. So that change of the marital property regime system is a costly exercise. Now, when you enter into an antenuptial contract, it is important, very important, to know exactly what it is that you're entering into and what it is that you are signing. With that said, a standard form would not suffice for this. You need to go see and consult with a notary, an attorney, so that they can explain to you exactly what it is that you're entering into and what it is that you are signing, just for the peace of mind and just for you to know what it is that you are entering into before you get married and what benefits it can bring you, and the advantages and the disadvantages of each marital property regime, and just what it entails and what it would mean for your marriage, and what it would mean if you should divorce in future. So it is very important to have an antenuptial contract. I believe being married in community of property is, there are certain advantages to it, but I believe it's just the safer option is just to enter into an antenuptial contract, especially if you don't have many assets. Let's just say you only have a house, maybe a house, or you do have assets, but it's not that deep. But you also don't want to, in case you divorce, you don't want to share those assets. It wouldn't be in your best interest to share those assets upon divorce. So if that's the case, it's enter into the just enter into an antenuptial contract without the accrual system, which is the simplest form, I believe, of it. And just be married out of community of property, enter into an antenuptial contract without with just exclude the accrual system, without the accrual system, and you'll be good to go. And because this thing of going to sign, another thing like South Africa, when you go sign at home affairs, that marriage is valid. I saw something the other day where I believe it was a lady in the rurals. Her children went to go sign at home affairs, and according to her, the only marriage that exists is a marriage that is under customary law, with those customs done and entered into and followed properly to procedure. And they don't believe that a marriage, when you go to home affairs and you sign, that is a civil marriage. When you do that, you are married, and you don't have an antenuptial contract. When you do that, you are married in community of property. The assets of your husband and you as the wife, they now it's a joint estate, and you will have to share it 50-50 should you divorce. It's as simple as that. Going to sign at home affairs, you are married in community of property if you do not have an antenuptial contract that is registered before the date of, or that is registered before the date of your marriage. It's just, if you are going to go to home affairs, if you are that in love and you see the need to get married quickly, then run to an attorney, get an antenuptial contract, then you can quickly go to home affairs and get married. Because I don't believe it's worth the disadvantages when it comes to being married in community of property are far worse than being married out of community of property. So it's not worth it to be married in community of property and you have to share your assets upon divorce. And that's all I have for you today. I hope you liked this episode. Please like, share, and subscribe, and have a wonderful day.